and you're never going to attract people in your organization. People sense it. You can't kid a kid, and you can't kid a grown-up. You either mean it or you don't. His generation sensed he ain't convinced. I ain't getting on the ark. To have effect in life, we have to be convinced and have to mean it. Noah is appropriate as a discussion this morning also because Noah was an example of God giving the world a fresh start. We're going to start all over again, wiping out the kidnappers and the thieves. We're going to start with one man, Noah. He was a righteous man in his generation, not in his generation. In effect, God said, I'll take it. You start over. Bankruptcy, we say lahavdil to separate the sacred from the profane. But bankruptcy is a system of a fresh start. Bankruptcy, Joseph, we're going to be talking about Chapter 11 bankruptcy, and rather than serve you the whole load, we're taking one slice, one thin slice, out of the many different subject matters that come up in bankruptcy. And we're going to talk about Section 363 of the Bankruptcy Code and sales of assets of the bankruptcy estate. And we'll define those terms in a minute, but just defining them right now, the person who flees into bankruptcy for protection from his creditors is the debtor, D-E-B-T-O-R. He's the debtor, and he has assets. Those assets form the bankruptcy estate. If he wants to sell one of those assets, he may. We're talking about Chapter 11 now, and I'll explain the difference from other parts of the Bankruptcy Code. But let's first take a look at the context, and let's see how we get down here to the bottom right corner, Bankruptcy Court, which is where we're operating. The U.S. government has three basic branches, as just reviewing the basics very briefly in a moment: legislative, executive, judiciary. The legislative is the Congress that writes the laws, writes laws on transportation, education, labor, immigration, defense, and it writes laws on bankruptcy. It writes economic laws. It wrote the Bankruptcy Code. The Bankruptcy Code had a predecessor called the Bankruptcy Act, 1898. In 1987, that act was thoroughly rewritten, and it's now called the U.S. Bankruptcy Code. Nickel knowledge, doesn't matter, but we operate under the U.S. Bankruptcy Code. In 2005, the Congress extensively rewrote and botched a lot of the provisions of the code, and we labor with that. But that's Congress writing laws. Let's skip the executive and go right over to the judiciary. This is U.S. starting from district courts. When you commence a lawsuit in the federal system, we're not talking about a state system. The United States has 51 systems of courts, one for each state and one for the federal government. There are certain powers that are federal powers. When this country was started, they said, well, we're going to have states, but they're going to be, and each one has its own integrity and its own separateness and its own rights and privileges. But we also recognize that the defense power has to be one army for the whole, and the postal power and transportation and commerce have to be federal law. So that's why Congress writes for the whole country. Any dispute that's going to involve federal law starts in the district court. If you don't like the decision there, you go up to the Court of Appeal. If you don't like the decision you got there, you go up to the U.S. Supreme Court, which is the last word. In the district court, all subject matters are present. Again, immigration, labor, transportation, defense, and bankruptcy. Bankruptcy is so complicated that the courts felt, the Congress and the courts felt, we're going to create a separate court as a child or stepchild of the U.S. District Court. And it's going to have separate set of judges that handle only bankruptcy cases. No immigration, no transportation, no defense, no taxation. Well, there are taxation issues. There are all these issues actually that come into our cases, but the bankruptcy judge, we've got 20 of them here in downtown Los Angeles and more in other courts. They have their hands full with the complexity of the bankruptcy code. Next. The types of bankruptcy in Chapter 7, Chapter 11, and Chapter 13. And Chapter 7 is, you are going to see it in a moment. Basically, you're liquidating, you're running a company, the widget company cannot go on in business. You're overwhelmed with debt. Future's not going to be better than the past. This is a burial case. We take the keys to the warehouse, turn them over to a stranger called a Chapter 7 trustee. He's a liquidator. He liquidates and holds a fire sale and sells all the assets, and you, the proprietor of that company, go out to the tennis court. You're no longer in business. Chapter 13 we're not going to talk about because that's only for an individual, not for a corporation or a partnership. It's just for an individual. It's got very low limits of debt, and we're not going to talk about that this morning. Chapter 11 is where we operate. Each chapter begins something called the automatic stay. That's a freeze, a stop sign in the hands of all creditors. If you enter bankruptcy, you're in a haven of refuge. You're under the umbrella and under the wing of the federal court, protecting you against any lawsuit. No creditor may commence a lawsuit against you, or continue an existing lawsuit against you, or send you a threatening letter, or make a threatening phone call. Any collection activity is frozen by something called the automatic stay. It's a freeze, it's a stop sign. And that's a big benefit. In Chapter 11, just getting past Chapter 7, Chapter 7 possession, the debtor stays in, this is in 11. Debtor stays in possession of all his assets, his business continues. He proposes a plan of reorganization, which is a restructuring of debts, and a creditors committee may or may not participate. If it's a larger case, there may be a creditors committee. Let's not consider that right now. But you see here that if you are a debtor in Chapter 11, you've suddenly got a big advantage over your competitors. You are at a time when none of your creditors can touch you. You remain in business. You remain in possession of all your assets. All your employees show up to work, business as usual, you're filling orders, you're letting your clients know this, we're in bankruptcy, there's no secret, there's no disgrace, we're reorganizing, especially in today's atmosphere where people are upside down on assets a lot. And so we're continuing business, and we don't have to pay our creditors whenever, and the airlines are fond of saying, you know, well, he's in bankruptcy, he doesn't have to pay the bank. We got to fly airplanes and buy fuel and employ employees, and he's got a competitive advantage over us. That is a fact. It's a huge benefit. And the court says, in exchange for doing you that favor, giving you that competitive advantage, and that breathing spell, and that fresh start, chance at a fresh start, I want something in exchange for you. What do you want, Your Honor? I want a plan. That's the third dot. The debtor proposes a plan of reorganization. And we say to the court, fine, you want a plan? You want a business plan? We'll send that up to you in a year. The court says not a year. 6 months? No. 4 months. 120 days, you come in here with a plan. That's the breathing spell that you get. Next. And who are the players? Well, we never got back to the U.S. trustee. When I said that we would defer talking about the executive branch, when we had this slide that showed the three branches of government, we had the U.S. bankruptcy, but we skipped over the executive branch. We had the Congress that writes the laws, the bankruptcy court that resolves disputes. But in the bankruptcy court, the judge has the help of a party in the, can we go back to that slide, please, the three branches?
And Jerry, you got about 5 minutes.
Okay, we're going to do it in 3 minutes. The executive, the president of the Department of Justice, has a little office called U.S. trustee. He supervises and helps a bankruptcy judge. Let's go back to Chapter 11, and let's get to the sale. All right, among the many adventures, we'll skip this. These are some of the players, but I want to get to one thing, a sale of assets in the bankruptcy case. There are stages, and we're here in stage 2, and we're talking about sales. Next. under a section of the bankruptcy code, the debtor, you are again, you run a business, the widget business, you're overwhelmed by debt, you want a breathing spell, and you want to keep operating, you may do so, and you may even use, sell, or